When we talk about estates, there are some key vocabulary words that we need to be aware of and how they are applied. The two general concepts that have vocabulary that we need to know are related to how an estate is granted upon death and when property is transferred. We'll start with the granting of property after death. When a property owner gives their property to their heirs, they can do it in two ways. The two ways are with a will and without a will. If a person dies with a will, we refer to that person as dying testate. After death, the will would dictate the disposition of property to the heirs. In the opposite situation, a person can die without a will. This person would be considered to have died intestate. If someone has died intestate, property will be transferred according to the laws of descent where they live. For example, if a person who is married lives in a community property state, dies without a will, the property will likely transfer to the surviving spouse. You'll see the terminology testate and intestate littered throughout discussions about estates and land because a transfer of property after death is one of the key parts of the bundle of rights. If a person were to die intestate and have no heirs, meaning the laws of descent wouldn't apply, their property would transfer to the government. The legal doctrine for this transfer to the government is known as escheat. Next up, let's discuss the second concept and some of the vocabulary associated with it. With certain estates, especially conditional fee estates, property rights are revoked after a condition is met or violated. If a property is granted to someone for a period of time, there's a question about what happens at the end of that period of time. There's two options. It can be transferred back to the original grantor, or it can be transferred to an entirely different third party. Now, if the property goes back to the original grantor, it's known as reversion. There can be specific language in the transfer of property which causes the property to revert back to the original grantor, and this language would be called a reverter clause. The reverter clause causes the property to revert back to the original owner. The original owner, or grantor, would be said to have a reversionary interest in the property because they would be the party who would receive the property after the condition was met or violated. Now, if the property is granted to a third party, that is a party that is not the original owner, they're known as the remainderman. A remainderman can be present in a conditional fee estate because it's not a requirement in a conditional fee estate that it revert back to the original grantor. It's perfectly allowed for that property to instead go to a third party, known as the remainderman. Besides conditional fee estates, you'll see the same language regarding remainderman in life estates. To wrap up with a quick summary, the things to remember are, if we die with a will, we are dying testate. If we die without a will, we are dying intestate. If we don't have any heirs, then it will go to the government, known as escheat. Now, keep in mind, if a property is given back to an owner, they would be seen as having a reversionary interest in the property, and should there be specific language saying that that reversion is in place, that's known as a reverter clause. Lastly, if property doesn't go back to the original grantor, the third party receiving the property is known as the remainderman.